Hello, everyone. At the beginning of August, people around the United States started receiving letters. The letters told them that their deferred action applications had been denied and they have 33 days to remove themselves from the United States or they would be deported. They were not expecting these letters. As you can imagine, it was very upsetting. Many of these individuals are in the United States because of serious medical issues for themselves or their family members. Today, I will talk about why these letters were sent, what it means for those who received them, and how USCIS has said that they will deal with these people in these situations in the future. My name is Raluca Hanea. I am an attorney and I provide immigration as well as estate planning and family law services to clients in Lawrenceville, Georgia. On August 7, 2019, USCIS, without notice, decided to stop processing all applications except DACA and military for deferred action. You have probably heard the term deferred action for people who are here under the DACA program. Deferred action is a discretionary determination to defer, that means temporarily postpone, the deportation of an individual who is illegally present in the United States as an act of prosecutorial discretion on a case-by-case basis. And I have explained before that DACA, the Deferred Action for Childhood Arrivals, does not grant legal status. I will post a link in the comments with that video. What it does is defer any action such as deportation being taken against people who have been granted DACA. And this means that the government will not deport them at this time. What I mean by saying it does not grant a legal status is that it does not give those granted DACA any right to be here in the United States. It merely says that the government will not actively work to remove them. It does give them employment authorization, so they are working and paying taxes just like those with a legal status and many without. And it means that they probably won't be deported. They must meet certain requirements, like not break the law, or they can be subject to deportation in that case. So it doesn't give them permission to re-enter the United States either if they leave. So in addition to the deferred action for childhood arrival, those are specifically DACA recipients, there have been deferred action granted for people in other circumstances. One of these types of deferred action is those for people who have compelling circumstances. And these are people who are not U.S. military members. They are granted a different type of deferment, which I will not talk about today. So often, these are vulnerable people in life-threatening circumstances. Some of these might have received a deferral of action under the medical deferral program. From 2012 to 2016, about 20,000 individuals a year were granted deferred action. When granted this deferred action, they thought they would not be deported while applying for a legal status. DHS and USCIS, like I said before, without any notice, stopped reviewing requests for deferments, except for DACA and military. Requests beginning with August 7, 2019. They did not inform anyone that they would be doing this. When they did this, any people who had submitted applications were sent the letters that I mentioned before. In these letters, they were told their deferment was denied and that they must leave the country in 33 days. These letters were sent to people who were first-time applicants for this program, as well as those who had applied for a renewal, and some of whom had been receiving renewals for years without problems. When people reached out to USCIS after receiving these letters, they were told by an agency spokesperson that, quote, USCIS field offices will no longer consider non-military requests for deferred action, to instead focus agency resources on faithfully administering our nation's lawful immigration system. And I close the quotes. What USCIS told them to do is that they now needed to apply to ICE for deferred action. When people called ICE to find out how to apply through them, ICE replied that they have no system in place to review deferral applications nor personnel trained to do so. So in essence, DHS, Department of Homeland Security, ended the program without any notice. Some immigration attorneys have said they wouldn't advise their clients to send applications to ICE. ICE's mission is to deport individuals. USCIS telling people to apply to ICE for deferred action is, in the view of many immigration lawyers, exposing them to deportation. If someone applies to ICE and is sent a notice to appear, they may lose their chance to apply for a green card at a future time. So those who have received medical deferred actions in the past were given 2 years deferrals by proving extreme medical need, and they could then apply for these to be extended. Some examples of those who have received them include families who have children with cancer, epilepsy, cerebral palsy, and muscular dystrophy. Immigration advocates have said that sending these children back to their home country is almost like sentencing them to death because they are not able to access adequate care in their home countries. That's why they ask for this to stay in the United States. Now, in addition to this, to the stress of trying to keep themselves or their children alive, these people are now wondering how they can remain in the United States. As of September 2nd, 2019, USCIS said they will start processing applications again. What they have said is that they will process the application that they had received before August 7, 2019. And it is still not clear if they will accept any applications in the future. So after USCIS changed their stance and said they would review applications received before August 6, 2019, ICE said they will not change their policy. They will not start accepting and reviewing any deferred action applications. They will not consider deferred action for any person until after a person has been through removal proceedings and has an order of deportation. So if you think sentencing children to death because they are not in the United States legally is outrageous, if you care about the lives of vulnerable children, if you think the USCIS should stay consistent to its mission of providing immigration services and not become another arm of enforcement, please reach out to your congressional members and let them know that this is not okay. USCIS, it's a government agency that it's paid for with your tax dollars, and they are removing themselves from any accountability or transparency to the taxpayers of this country. So let your congressional representatives know this is not okay. All of the federal agencies in the United States should be required to be open, transparent, and answerable for their policies. They should not be able to eliminate those in effect for decades without following established guidelines of notice and public comment. So don't allow your government to act however they want. While this decision might not impact you today because you are here with a legal status, if you continue to allow this administration change policy without accountability, who's to say that tomorrow, when it is too late to do anything, that your rights won't be taken away? So no one, including those who work in the federal government, should be able to act without following established policy and protocol. This nation was established with a system of checks and balances. So please don't let that be ignored until it is too late. Thank you for all of you who are watching and the ones who will watch later. Thank you for all your likes, shares, and comments. Please reach out to us with questions about your immigration case. We are always here to help. See you later.